not complimentary, but yes, I know what you're referring to.
Okay, so there were derogatory comments in your exchanges with Ms. Lure?
I believe it was, why is Vince posturing? Is that what you're referring to? And then he's being dramatic? Is that what you're referring to?
Right, so
Yeah.
one of the people in the meeting, Jennifer Lure, was in real time texting you about the meeting, and she was critical of Mr. Goddard, correct?
Judge, I'm gonna have to object. I don't see the relevance of this line of questions.
Well, I'm going to give Mr. Calderon a little bit of latitude.
Your
They'll
Honor,
tie
this
it
is the
together.
last question on this topic.
Good.
I'm sorry, yeah, I think it's fair to say that, I don't know that it was like vitriolic, but it was fair to say somewhat critical, yes.
Now let's talk about the second meeting. Jennifer Lure was in the second meeting, correct?
We're now talking about the February 12th incident review?
Yes, sir.
That's correct, yes.
Okay. But in this meeting, Clint Davis was present as well.
That's correct.
You characterized him as Clint Davis, a gang expert, correct?
That's correct, yes.
What makes him a gang expert?
Oh, he has a lot of training and experience, years of experience with the Phoenix Police Department, working in the gang enforcement unit, and then after that, he worked for the sheriff's office. I think he continued to do he did continue, I believe, to kind of look at gang-related cases. So, he is an expert.
And isn't it true that it was his opinion that this was correctly charged as a gang case?
Objection to the extent it calls for a legal conclusion.
Yes, that was his opinion.
The first meeting that you testified about having, Alistair Adele was the county attorney at the time, correct?
Yes, she was the county attorney during both the October 30th meeting, although not present, and then also at the February 12th meeting where she was present, yes.
I want to make sure thank you. I want to make sure I got this right. It's my understanding that she ultimately said dismiss the charges without prejudice, correct?
When you say ultimately, I guess there's two different, on February 12th, ultimately, that day, dismiss all the charges without prejudice, and then in June, as it relates to the October 17th case, dismiss the remaining charges with prejudice.
It was still Alistair Adele giving those orders in June.
That is correct, yes.
Okay. And how did she communicate that with you?
Which decision?
The latter.
The latter being in June. My recollection, and it's not perfect on this, is that I went up to the 6th floor prior to going to what would have been an oral argument in front of Judge Ryan Toohill, and I wish I could remember exactly who was there. I think it was Ken Vick, Alistair, Ed Leiter might have been with me, and there might have been one or two others. I don't believe Jennifer Lewer was there, but that's my recollection is when she said, let's dismiss it with prejudice.
Let's talk about the umbrella.
Sure.
And I have heard of the court, learned colleague across the way, and to you, that the nomenclature for the umbrella, the thing at the end, I forgot what you called it,
The Mary Poppins?
the wanky part. You called it the wanky part of the umbrella.
Did I call it that?
Yeah, but that's okay. It's fine. I would have called it the wanky too. It's called the tip.
Okay.
The tip of the umbrella. I looked it up. So
All right.
let's talk about the tip of the umbrella. Did you see any photographs that had sharpened tips of umbrellas?
In the photographs of the umbrellas,
Yes.
let me sure I understand. Did I see any sharpened tips?
Tips that would not look like it was the manufacturer's intent.
Yeah, I did not see any tips that appeared to be modified beyond what the manufacturer did. I did not see that.
We're going to direct you to exhibit exhibit 120.
120, okay. Oops. I'll trade you. Yeah, I see 120. Appears to be the PowerPoint. Actually, there's something stuck in here. Yes, I see
Well,
that.
that's something we'll go to next.
Okay.
the exhibit 120 has the word seen, S-C-E-N-E, up in the left-hand corner. That's not it.
Oh, I'm sorry.
It's 120, it's in the book right there.
I'm on 120, and it's, you wanna see what I have? It starts out with it appears to be PowerPoint.
It's toward the end of the PowerPoint.
Okay, give me a second. Oh, I do see what you're looking at now, yes.
That was the photograph that you saw, correct?
I've seen this photograph before, I saw a number of other photographs. as
Was
well.
that the photograph that you reviewed when you, in reference to your testimony here, that you didn't see any sharpened tips?
This would have been one, I reviewed multiple photographs of umbrellas, because they took more than one photo.
Right next to it, inserted in the book, you pulled it out earlier.
This.
Was this. That is a uncropped version of the same photo. Can you compare them?
Yeah, I mean, it's showing some of the same, it does appear to be the same photograph, that's correct. It's just about a cropped version.
And isn't it true that the uncropped version has an umbrella with a very pointed tip?
Well, it looks like it has yeah, it has I guess it's fair to say it has a pointed tip that did not appear to me to be modified. It's just it's a tip.
So you say that this is, the manufacturer would have prepared this umbrella with a very sharpened tip?
I mean, it appears, I guess what I'm looking at, it appears to be black, you know? So it looked like from the photograph that it was still like a rubber, it was the rubber tip. Or I say rubber plastic or whatever it is, but it didn't look, I don't see anything that is telling me that it's been modified, like sharpened and changed.
Would you compare and contrast that to the umbrella that is at the bottom of the page? At the forefront, bottom of the same photo.
And is it okay if I hold it up? Are you talking about this one?
Yes.
Yes.
Would you compare that tip to the, I'll call it, needle-like tip on the other?
Yeah, I mean, I can see that this tip, the other one, is definitely thicker. I mean, that is something that I remember seeing this, and I remember thinking, okay, is this modified? And it didn't appear to be modified, and then I was never presented with any evidence that somebody actually
Okay,
took
the
them.
question was for you to compare it.
Sorry.
And I think you answered it.
Okay,
Thank you.
thank you.
Thank you so much. We broke yesterday in the middle of your testimony, correct?
I think it was Tuesday.
Tuesday, I'm sorry.
Yes.
Tuesday. We're working every day.
It's okay.
Everybody in the room is working every day. Do you have a lawyer advising you in this case?
No.
Okay. Well, I don't want to invade any attorney-client privilege with the questions, but did you speak to anybody about your testimony here in between when we recessed on Tuesday and now?
Well, I mean, I just spoke with the bar, scheduling and then answering a few questions to make sure that we understood what the facts are.
Well, what were those questions?
Well, I mean, I don't remember every single question, but one, for example, would be the process that I talked about where Ken Vick had asked us to, you know, sort of create this team, or where he wanted us to create a team and review submittals. I suppose I'm trying to think of what, I know there was other facts, I just can't think of them right now.
Did you talk to them? You said you just talked to them.
Oh, I'm sorry, I think I also mentioned in my deposition, I had reviewed the deposition, and there was a typo where it said, instead of lying attorneys, and then there was one where between you and I, we were talking about whether it was a cell phone versus a home phone, and I let them know that, I don't know what my brain was thinking, but it would have to be a cell phone because it was texting, so there was some of those things.
And did you have just one conversation with the bar, or did you have several?
Oh, since my testimony?
Between Tuesday when we recessed and this morning's testimony?
Well, it was more than one, 2 or 3.
Okay. Were they in person?
No.
Okay. And were they telephonic?
Yeah, telephonic.
Did you exchange any emails?
I think other than like, are you in right now? I did, like, for example, I did reach out to them to, let them know about certain things that I figured might be pertinent, that might be asked about, things like that.
So you were,
Things
why would you call them, why would you communicate with them to let them know what would be pertinent?
Well, because I wanted to make sure, since they're the ones who are presenting the case, that the testimony, that what I'm bringing out, what's coming out is accurate.
Did they in any way coach you on what to say?
Not at all. Not,
Did
in
you
fact, the
have-
opposite.
Did you have any, the opposite, explain what the opposite was.
Mr. Henley said, your testimony is your testimony, and you answer it how you feel comfortable. You know, I'm paraphrasing, I don't know if those are the exact words, but.
No, that's my knowledge of Mr. Henley, so yes, thank you very
Yeah.
much. In your deposition, you testified that you only viewed dozens of the videos, correct?
I think you asked me to estimate, and I wanted to be I'm careful, so yeah, at least dozens, yeah.
Do you know how many videos there were?
Body cam videos?
Videos that a prosecutor would review?
Oh, God, I mean, in this case, I think over 100, and, you know, and just so you know, in hindsight, I think I would not be surprised if I actually did review, you know, if not all of them, almost all of them.
Okay, if I were to tell you that there's over 150, would that be reasonable?
No, I think that's correct, actually.
And that's my count, and I was lousy at math.
Me
So-
too.
So, there's that. Do you believe you reviewed all 150 videos?
I believe that I believe I reviewed either all of them or almost all of them. And then certain videos I would have reviewed multiple times because they were very pertinent.
Over what period of time? How many days, weeks, hours? Over what period of time did you review this?
My review, the beginning of my review would have been when I got access to the case, at least February 8th. I can't remember if I reviewed body cam on that day, but I may have. And then I think it's fair to say that I stopped reviewing those body cams, at least in terms of preparation for my review of the case, when it was dismissed with prejudice in June. So that period of February 8th to early June,
About 5 months, over 5 months.
around there, yes.
Okay,
Wait, let me do that again. Yeah, February, March, April, May.
I'm
Yes.
guessing.
Yes,
Once again, my math is not good, so please double check. So over 5 months, you reviewed these videos, correct?
that's correct.
Isn't it true that 5 months is a lot longer time than a line prosecutor would have to review videos, particularly to review 150 videos, particularly with a 10-day deadline in order to protect the defendant's rights?
Can you rephrase that?
Is it possible to review the 150 videos within the 10-day time frame that a prosecutor has in order to evaluate the case to move forward?
I think I know. Tell me if I'm going to rephrase what I think you're
Go right
asking
ahead,
me.
go right ahead.
If you have, let's say, grand jury set within those, the probable cause of termination required within 10 days, is it feasible to review that many body cam videos? No, it's not feasible to review that many body cam videos.
So
And unless, I mean, no, it's not feasible. It's just not.
so it's safe to say that, based on what your testimony is, and correct me if I'm wrong, that it's reasonable for a prosecutor, based on their caseload, based on their personal life, not to review every single video in that short time frame that you have to work under because of the constitutional protections, correct?
So that is correct if you must work under that time frame. It is not possible to
Right.
review that many videos, and it is also common for a prosecutor to not be able to review every single body cam video in a complex case prior to grand jury, again, with the caveat of if you must present by that time period.
So just to close up this area.
Yes.
So you had a lot more time to review these videos than April Sponsel had when she was reviewing them at the onset of the case, correct?
At the onset of the case
Yeah.
prior to grand jury, yes, I had more time.
Okay. Did you have a conversation with an officer named Ben Moore regarding the decision to dismiss the protest cases?
Yeah, yes, I mean, I don't know that I had a conversation with Ben Moore. Yeah, after the dismissal without prejudice, correct, yes.
Who is Ben Moore?
He was a lieutenant in the I forgot the exact name, it was Downtown Operations Unit, or it was essentially the group that's responsible for responding to the, security downtown and protests, things like that.
Would that be City of Phoenix Police?
Yes, it would be, yes.
And you testified earlier about the federal, somebody from the Federal Bureau of Investigation being involved, also Mesa Police. So am I to draw the conclusion that relative to these riots or these protests, that there was an interdisciplinary group of law enforcement agencies collecting intelligence?
Yeah, I mean, I think that's fair to say. I don't, how well they communicated is a little bit, that's a different issue,
Yeah,
but yes, it's fair to say that you had different police agencies that were trying to figure out, who's gonna be showing up at these events, is there gonna be a danger to them? So they would have to kind of collect general information, and they were sharing information.
So when you let Van Moore know that the case was going to be dismissed, I think you said without prejudice, what was his reaction?
Objection, relevance.
What is relevant about that?
What Mr. Moore was one of the people upon whose opinion my client relied. And
Yeah,
so
and
her state of mind,
I certainly can understand your client testifying about reliance on him, but I'm not sure that this witness, we're also getting into hearsay. I'm going to sustain the objection to the pending question.
Is it my understanding that your testimony here today was that Alistair Adele dismissed the case for insufficient reasonable likelihood of conviction?
Are you talking about the dismissal without prejudice on February 12th?
Yes.
Yeah, I mean, and I say that because we had the, the incident review, and we looked at the strength of the evidence as to the felony charges, and the consensus is that there was not a reasonable likelihood of conviction on the felony charges. There was discussion about how, there are these misdemeanors, but ultimately the decision was made, and I obviously, I can't speak to exactly what Alistair was thinking, but my recollection is that generally it's that we need to dismiss this right now and sort of start over and make sure we have the facts right if we're gonna be bringing charges in the future.
And in the process, in the process of your career, any prosecutor's career, this sort of thing happens, does it not? This is not like Halley's Comet. I mean, it happens.
That is to say, like a reevaluation of the case?
Correct.
That's correct, yes.
I want to ask you a little bit about your testimony relative to the assisting a criminal street gang
Yes.
statute. In order for that statute to apply, is it my understanding that your testimony is that you have to have evidence that these people participated in previous felonies?
No, so you have to be able to show under the definition of criminal street gang that this is an association whose members individually or collectively commit felony offenses, preparatory or otherwise. And so while you don't have to have felony convictions in order to prove that this particular group is a gang, most of the time the gangs that we're dealing with are well-established criminal street gangs, and there really is no question about whether or not they individually or collectively commit felony crimes. So you don't have to have it, but it is certainly going to be important.
So how do I qualify my street gang to be a street gang if this is going to be our first big thing? Under your analysis, can a street gang ever become a street gang without having been previously a street gang?
The answer is yes. There are instances where, for example, a group emerges that's new, and however, under the facts of the case itself, and I'm just giving this as an example.
Sure.
Under the facts of the case itself, you may have, for example, a distinct group, and as they're being investigated, it's determined that they've done multiple armed robberies and drive-by shootings. So as part of the overall evidence in the case, you have a good track record that this group, this association, individually or collectively commits felony offenses.
And your interpretation of the statute is there must be a track record.
No, sorry, so I'm not saying that.
I don't practice
Yeah.
criminal law.
Yeah.
Your little finger, you know a lot more than I do in my entire body. So you're saying usually, I guess, you look to see if there is some sort of pattern or practice in the past.
I guess the way I would say it is that the language of the statute is gonna require showing individually or collectively commits felony offenses. And so, while you don't necessarily have to have a track record, it is gonna be extraordinarily important in terms of persuasiveness, and not only persuasiveness, to make sure you got it right, that this group really is, number one, an association that is associating with one another. Number two, that they really do individually or collectively commit felony offenses.
So just to try to put a cap on this, it's my understanding that when you reviewed this, and you testified earlier today that you reviewed it, and you didn't see any previous experience as a street gang, that made you uncomfortable proceeding the way it was. That's what prompted you to continue to dig.
Well, not necessarily, because the chronology there, I think, kind of conflated two things. So, is it okay if I explain?
No, sure.
So initially, we have the October 30th meeting. The information that's being presented, I have no reason to dispute or disbelieve the information that this group had communications with each other, had sharpened umbrellas, had sharpened fingernails, that they had come together for the purpose of assaulting officers. So there's this conspiracy to commit aggravated assault. I believed the information. My concern, though, at that time, though, is that, I can understand a group, if they have this intent on this particular night. We need to be very careful, though, about labeling a group a criminal street gang unless we really are sure that this is a gang. And a lot of times, the way in which we're sure is that track record of individually or collectively committing felony offenses. And I go a little bit farther. I know the statute, the way it can be read very broadly. One of the things that I've always thought about in terms of the gang statute is that you have to look at what the purpose of the gang statute was. What conduct was it intending to meet? And so I had, very grave misgivings on October 30th about the gang statute at that time. At that time, I did not realize that what I saw as being core facts turned out not to exist. But I was concerned at that time that we just didn't have enough evidence to show that it was a criminal street gang.
And you would have felt better if there had been evidence of some sort of previous incident where they acted as a street gang.
Yeah, I would say multiple. I would have felt better if there was, multiple incidents.
Multiple.
Yeah.
And in order to charge the street gang, do they all have to be, every single person involved, do they have to be a member of the street gang in order for those charges to occur?
No.
Okay. And the Maricopa County Attorney's Office didn't create the gang statute, did it?
Well, that's the legislature that passes the laws.
People we elect, right?
That's correct.
Wants to be changed, like you said, you're not comfortable with parts of it, you've got to go to the legislature to have it changed, right?
That's correct, yes.
But it's the law,
It is the law.
and you and I have to follow the law.
We do, but as a prosecutor, I also have to interpret the law.
Absolutely, absolutely. I'm very glad you do. Umbrellas.
Yes.
This will be a shock to the tribunal and to my colleague, but I've protested before. And I've never protested with an umbrella. And so, in preparation of today, I watched the Reverend Martin Luther King's protest march on Washington. I didn't see any umbrellas. What's the purpose of an umbrella in a protest?
So,
Objection, Judge, that's speculative.
Well, if you know, you can answer.
yeah, I think I can answer.
Sure.
In the context of, like, for example, the modern usage, what we're seeing. The umbrellas are part of an overall tactic, that is consistent with, for example, black bloc, and it's designed to conceal identity, and essentially prevent identification by police during the course of a protest. Generally, is how it can be used. That's my understanding.
Would it be fair to say that law enforcement disfavors people protesting using umbrellas, trying to conceal their own identities?
Well, there's a lot of things that conceal identities. Masks are often used, that conceals identity. The entire, again, black bloc is designed to sort of conceal and confuse identity. So that, my understanding from the review of this case, and also frankly just generally kind of following things in the news, is that yes, I mean, the umbrella is designed to make it more difficult for identification.
Black bloc, what does that mean?
It's essentially dressing in all black, oftentimes including, like a black mask, making it, again, difficult to distinguish between, if you have a large group of people, and if everybody is dressed in black, it can kind of look like a swarm, and so it is difficult to pick out certain people.
Isn't it true that Ryder Collins was wearing black and gray that evening?
So I know this came up during the deposition. Ryder Collins was not wearing black bloc at all. He was wearing black shorts. I've now looked at the photo. He was wearing black shorts and I believe black shoes. But he was wearing shorts, number one. There was, I think, one other protester that evening who was wearing shorts. But usually black bloc is, pants, shirt, mask, hat, complete with the umbrella. He was not in black bloc.
And where would I find that definition?
Of what, black bloc?
Black bloc.
Go online, Urban Dictionary, Wikipedia.
Could another prosecutor have a good faith different opinion than you as to what black bloc is?
In the context of Ryder Collins?
Not Ryder Collins, but in the case of identifying black bloc, could you have an idea that it's not black bloc and a colleague of yours have a good faith idea that it was black bloc? Is that reasonable to
This is all
expect?
speculative.
I'm sorry, say that again?
This is all speculative.
Well, do you know the answer, Mr. Green?
I guess if the question is it possible? It's possible that
Tell me.
in a different situation, you could look at two different people wearing clothing and have a disagreement on whether that constitutes black bloc. And again, my emphasis is in a different situation because I do not believe Ryder Collins could reasonably be characterized as wearing black bloc.
A question for you. In your experience as a seasoned prosecutor, have you encountered the Federal Bureau of Investigation misleading you in very many cases?
Misleading me?
Yes.
My personal experience,
Yes.
I don't believe I've had I don't recall personal experience where I felt that the FBI was misleading me. I'm aware of other instances where there's been frustration.
I'm only testing
Oh, I'm
about
sorry.
you because you're the.
Yeah, I'm sorry. I
you're the guy-
don't recall
All right.
ever feeling that the FBI had misled me. I don't recall that.
What, same question, interchange in the Department of Homeland Security.
The same
Famous
answer.
lady.
I don't recall.
What about Mesa Police Department?
I don't recall Mesa Police Department misleading me.
What about Phoenix Police Department?
I don't recall Phoenix Police Department ever intentionally, like, there may be times where I felt that a report was misleading or the way in which something was phrased was misleading, but I never felt that there was ever an intent to mislead me as a prosecutor, if that makes sense.
You testified that there was some sort of intelligence, it might have been a posting involving Amy Beth Capers, where you testified she wrote riots 2020, burn it to the ground.
Something to that effect, yes. I mean, I could, if you have a copy of it, it would refresh my recollection.
No, I'm relying on your testimony,
Okay.
so that's fine.
Actually, you know what? I believe it might be in this exhibit. Do you want me to look at that?
I'm not gonna
Okay,
spend
never
much
mind.
time on it unless you want to.
No, that's okay.
Okay. Burn it down. Is that a call for a peaceful action?
What definitions are we using here?
Your Honor, he's a prosecutor, he takes a look at this.
I think your direct examination opened the door to this social media post overruled.
Can you repeat the question? I'm sorry.
Well, the posting says riots, burn it down. Is this message intended to elicit peaceful protest?
Objection, Your Honor, now we're in the speculative.
Well, I agree. Your first question was not objectionable. Now you're asking about the intent of the author. So if you could say it like you did the first time, I wouldn't have a
If I
problem.
could remember it, Your Honor, I would.
I think the question is whether Ms. Caper's post is reasonably consistent with a peaceful plan.
Thank you, Your Honor.
Yeah, I don't think riot and burn it down is consistent with peaceful protest, if that's what you're asking.
Alistair Adele was the subject of some controversy, and eventually he had an unfortunate circumstance. You were one of the people that wrote a letter of protest about her, weren't you?
You mean the request for resignation?
Yes.
Yes.
Why did you do that?
Well, I guess that's kind of a complicated matter, but in the sense that there were a number of things that led up to it, but we felt that ethically we had an obligation at that point to request that she resign, and we also felt that ethically we had to report it to the bar and the Board of Supervisors.
Okay, when you say we, who are we talking about?
Oh, I'm sorry, the division chiefs at the time.
Okay. But yet, you also testified here today that she ultimately told you to dismiss the case with prejudice, correct?
Yeah, well, chronologically, the decision to dismiss the case with prejudice, that occurred in June of 2021. And then, of course, my recollection of the chronology is, you know, she goes into the rehab, I think, in September of 2021. And then we started having these additional concerns in November of 2021, ultimately culminating in early 2022, with, I believe it was February 14th or so when that letter was sent.
So just so I can close this loop up, you had confidence in her when she told you to go ahead and dismiss with prejudice, but later in the year, after she sought medical help, you did not have confidence in her leadership.
I think I had, yeah, I think that's fair to say. I mean, I had, and just so that I'm being transparent, in the February 12th incident review, there was a text message that I believe you have where Jennifer Lewer had asked if I had spoken to Alistair about this October 17th case, because she apparently thought that we had, and I had not. So I did, in the back of my mind, have a little bit of concern about lingering effects from the surgery, but I guess to ultimately answer your question, I didn't have any concern about her ability to make the decision to dismiss the case with prejudice in June.
You testified that the catalyst that prompted you to take a look at this is you were watching a television program, correct?
Yeah, so the old, I guess the sort of the, because I was not her supervisor, it's not my division, what it is that really kind of made me, I don't know, for lack of a better phrase, stick my nose into the case was that report on February 4th where I saw Ryder Collins.
And this was, you knew then it was going to become a highly politically charged case, correct?
I don't know about politically charged as much as I did recognize. I mean, I recognized that this was going to be a high profile, very publicly visible. And I suppose it's fair to say that under these circumstances that could have, I suppose, political ramifications, but that's not what I was thinking of. I was thinking of this guy, Ryder Collins, has just said, I don't even know these people, and that's what really prompted me to take action.
So I don't want to misstate anything.
Sure.
It's my understanding that at that time, this area of the gang activity, the charges and stuff, was not in your area of authority, correct?
But yeah, that case, this October 17th case, was not my case, not my division. I don't supervise it, I didn't charge it, exactly.
So you you wanted to be part of this case, correct?
I wouldn't say I wanted to be part of the case. When I saw that report, I wanted to see if I can help. Basically what my email to Ken Vick was, I think pretty much sums it up. You know, I think that this needs to be, we need to have an incident review, and I asked for permission to assist, essentially. You know, I have enough work on my own, but at the same time, yeah, I felt that it was important for me to offer my assistance and for that matter, have some involvement.
It's good of you, particularly with the workload you have. Are there any other cases that served as a catalyst for you? You're watching a particular news program. In this case, it was ABC15 News, correct?
Yes.
Okay. Are there any other cases involving ABC15 News that you saw, and then you said, I've got to get involved in that case?
I don't want to say no and then find out that I'm wrong.
This isn't a trick question.
Yeah, I can't remember right now.
If you can't remember, you can't remember.
Yeah, the only thing I was gonna say is that so again, it's not my division, but in September, September of 2020, before all of this, October 17th matter, and I don't know that it was ABC 15. There was something in the news about a lawyer who was representing other protesters saying that he's received no discovery, he's received no video. And so in the office, I'm kind of one of the guys that deals a lot with discovery issues under our Rule 15. And I just wanted to, you know, I don't like seeing like, oh, the county attorney's office isn't disclosing things. So in that context, and I believe we'll call it the Bruce Franks case is the case that it was, another August case, I had just quickly reached out to April and say, you guys should really try to get those body cams out or videos out.
Even though April was not in your area?
That's correct. So, but just to be clear though, that type of a thing where I call another prosecutor like, hey, you know, I saw this, maybe not in the news, but you know, I heard about it, you know, in court or something. It is not uncommon for me as a division chief, and even not as a division chief, to just talk to other prosecutors if I think I can be of assistance. In other words, if I see what might be a problem, if I can be of assistance, I may try to help out, but that doesn't mean that I'm gonna insert myself into the chain of command and give any type of an order.
Somehow from your previous testimony, I got the impression that there's a manpower shortage, generally speaking, in the prosecutor's office?
That's correct.
Okay. And was it unusual for lawyers to ask for additional help?
No.
Was it unusual for lawyers to have those requests denied?
A request for additional help?
Yes.
I think, I don't, it's hard to characterize. I guess it depends upon the extent of the need. Because when you think about it, if everybody is shorthanded, it's possible that you know, somebody, an executive or a division chief may say, I just don't have anybody that I can give you right now to assist. But I do feel that generally in our office, we do try to make accommodations. We try to find people who can maybe, you know, help out on some cases, review some cases for charging, things like that.
So do you know, in the case where April Sponsel asked for additional help, and she did not receive it, why she didn't receive it?
On which case?
The gang cases.
Oh, this case?
Yes.
This particular October
Yes.
17th case?
Yes.
Do I know if she reached
Do you
out?
know why it was denied?
Objection, it really asks and answers questions that aren't in evidence.
Well, I think you're jumping ahead a question, because I think he's going to say he doesn't know that there was a request. So I think you need to back up and ask whether he's aware of a request.
Were you aware of a request?
I don't recall. If you have something to refresh my recollection,
No, it's okay.
I actually don't recall.
Do you know if
that.
she asked for help in other cases?
Just general, I mean, there's like, knowing her for so many years, there's probably time like, hey, Ryan, can you review this motion? Hey, Ryan, can you, so yes, she's asked for help. We all ask for help at some point of a colleague.
And do you know if she's ever been denied help?
I'm sorry, I don't know.
Okay. Did you review all of Ms. Sponsel's cases and the evidence in those cases as part of this review?
All of her cases?
Yes.
No. You mean like her entire caseload?
Yes.
Not at all, no.
How did you determine what cases to review and what cases not to review?
it was basically the assignment, so I get assigned the October 17th case, that's what I'm gonna review. I get assigned that August Sue Varner Ratnam case, I'm gonna review that. Then we get that general, you're gonna be part of a team, Ryan Green's sort of the division chief, like the highest ranking person in that team. And then, so I may not have dug as far into some of the other cases, but when, for example, Ed or Neha or Susie Coughlin would come to me with one of those cases that if it wasn't assigned to April, it was assigned to somebody else in FRB, I might review it, but it might be more of a cursory review. It would depend on the circumstances, but I definitely did not review all of her cases.
And when you say if I was assigned, who made the assignment?
Well, I know the October 17th case, that was assigned by, Ken Vick asked me, he's like, or told me, you're gonna review the October 17th case, you're gonna have that. And then, I think like a day or two later, hey, there's this one defendant who's part of that case, it makes sense for you to take that, so then that got assigned to me. And then I don't know exactly how it got decided by Ken or somebody else, but then eventually Ed and Neha get certain cases assigned to them. I know Rachel was at least reviewing some, but I don't know that it was, quote, assigned to her.
Do you know how MCAO determines when to provide lawyers with additional resources or help compared to when they decide not to? Is there a litmus test or criteria?
I think it's sort of the common sense, evaluating how urgent the need is, what the time constraints are, what resources are available, what resources can be spared. It's just it's a totality of the circumstances.
Can urgency arise out of a public sentiment?
An urgency arise out of public sentiment alone. I don't think I would say that it would arise out of public sentiment alone. I mean, I guess the best way to describe it would be that a case that is very important or has become important that is what may arise, or sort of arouse the public sentiment, but it's not the public sentiment that would dictate where the resources go.
Let me
At
ask
least
you
it
about-
shouldn't work that way.
I want to understand important, the word important. I have a friend who's interviewed, he's a former bar president, fantastic lawyer. When everybody sticks a microphone in front of him and says, what is your most important case? His response is, yours. Great sales technique. How do you decide what's important?
Well, like generally within the Maricopa County, some of it is going to be, the nature of the case. So for example, I don't think there's any dispute that a first-degree murder is going to have to get more resources than, say, a misdemeanor driving on suspended license. So the nature of the case, the public safety implications of the case, those are just some of the factors.
So is it possible the reason that April did not receive help in certain cases is that they were not important enough?
Well, again, I don't know what she didn't receive help on.
Generically speaking, I think, are you saying that if it's an important case, resources will flow to it? If it's not an important case, resources will be withheld?
Not entirely saying that. I mean, every case is different. It's a totality of the circumstances test, or I say test. I mean, that's what we look at. I get requests all the time. Hey, in my division, we're really hurting over in the game bureau right now. We need assistance. A prosecutor needs help on this case, and an email can go out and ask for help. So I'm sorry, I can't answer like what went into a decision if a decision was made to not provide April assistance on a certain case.
There's no right or wrong answer, just your opinion is
Okay.
important, but thank you, and I appreciate your answer. Can reasonable minds differ as to what's important and what's not important when they're talking about allocating resources?
I think generally that's a correct statement. Obviously, you will always hit a point where if somebody, again, is comparing a driving on suspended license to a murder, then I don't know that reasonable minds would differ. But I mean, yes, in a lot of instances, there's no question that reasonable minds can differ on which case should take priority.
Generally speaking, do deputy county attorneys work hard?
I believe so, yes.
Are some of them overworked?
Absolutely.
Are some of them exhausted?
Absolutely.
Do you think reasonable minds can differ on the determination of probable cause?
Yes.
And to determine probable cause, does that mean the probable cause equates with the likelihood of conviction?
They're two separate analyses.
Could you explain those two separate analyses?
Sure. So, probable cause is, are there articulable facts and circumstances that would lead a reasonable person to believe that, number one, a crime was committed and that this particular person committed the crime. That is, it sort of begins as a constitutional standard. It's also from the ethics standards, it's the bare minimum that a prosecutor must have before bringing a charge. However, reasonable likelihood of conviction is our office's internal charging standard. It's a higher standard, and a lot of prosecuting agencies have adopted the reasonable likelihood of conviction standard. Like probable cause, it's certainly possible that reasonable minds can differ on what constitutes a reasonable likelihood of conviction, but the idea is that given what we expect to be the admissible evidence at trial, is there a reasonable likelihood that a jury would find this person guilty, that we would be able to prove our case beyond a reasonable doubt?
So, probable cause is no longer the standard. I'm just trying to interpret what you're saying. When one of your prosecutors determines to file charges, they're not to say, is there probable cause here? They're to say, is there a reasonable likelihood of conviction?
That's correct, yes.
And that's a policy of the office.
That is an office policy, the reasonable likelihood of conviction standard.
And is it in writing anywhere?
Yes.
Okay, and all deputy county attorneys receive that information, correct?
Yeah, I mean, first of all, that's part of, our basic training. And then, yes, it's in our charging policy. One of our many charging policies, yes.
Were there any people let's start with the first meeting. We're talking about the collective meeting, the one without Clinton Davis.
Correct.
Were there any people in that meeting that disagreed with the reticence to move forward on the case?
I think that's kind of a double negative. So, you want to re-ask it? I think I understand what you're saying. I just want to make sure.
Did anybody in that first meeting say, no, but this is a bona fide case, we need to proceed?
Well, while I don't remember the specific exact words, that's certainly my impression, yes, that there were people who said, no, these are righteous charges.
And the righteous charges are essentially the charges that Ms. Sponsel came up with, correct?
Yeah, so I mean, my recollection is that the charge reported by, her, Vince Goddard, Sherry LaCrone, and April Sponsel, at least, I feel confident that they were in support of the charges.
Right. And Sherry LaCrone is April's direct supervisor, correct?
That's correct.
And she supported the charges?
Well, that was my impression. I don't know that she said a lot during that meeting. In fact, I don't have a specific memory of what she said, but I guess maybe the best way to put it is that if she disagreed with it, I'm pretty sure that she would have said something, and I would have remembered that. I don't remember hearing any disagreement from her.
But Vince Goddard spoke, correct?
Vince Goddard spoke.
And he spoke in favor of those, proceeding with those charges?
Yes, I mean, without recalling exactly what he said, my impression was, yes, he believed that at that time, that those